I always wanted a walk-up song, so I guess now I have one. Oops. Anyway, hi. So I'm going to be, as they said, I'm going to be talking about the application pitfalls. So I'm going to also try to remain optimistic, like Lillian said, but it's a little bit difficult in the face of these pitfalls, so let's get into it. So I'm going to be talking about the pitfalls both with PMTAs and substantial equivalence applications. It sounds like a lot of you are not in the process of, haven't submitted applications, but this would be good information even if you're a retailer or distributor. There are a lot of application pitfalls. My experience is that FDA will do everything to find a reason to reject your applications at every phase that they can reject them. So you really have to be, God, this light is bright. You really have to be vigilant about checking all the boxes, as Lillian said. Don't give them any reason to reject your application. And there are 3 phases at which FDA can reject your application. There's the acceptance phase, the filing phase, and then the ultimate scientific review phase, where you get either a marketing granted order or a marketing denial order. And I'm going to talk about each of those phases. FDA has issued, especially for the synthetic applications, has issued a lot of refuse to accepts for very, very ministerial reasons, kind of absurd ministerial reasons, to be honest. So let's get into that. So FDA has a regulation now that sets forth the grounds for when they can refuse to accept a PMTA. And I won't read this slide to you, but you can see that there are some pretty nitpicky reasons, and FDA has interpreted these requirements as strictly as possible, arguably stricter than the regulation allows, but they will do whatever they can to reject the application at the earliest phase possible. Oh, you're taking pictures of that? Do you need me to go back? There we go. Got it? Okay. So just to talk about some of the more common bases of late for the refuse to accepts. Doesn't include an environmental assessment, which Lillian referenced earlier. You're required to have an environmental assessment in your application. And it's a pretty challenging requirement, so you would need to work with someone who's an expert in preparing those environmental assessments. One of the most common reasons for refuse to accepts for a lot of the synthetic applications that came in after the effective date of the PMTA rule was that the application didn't include the most recent and final versions of the required FDA forms. Now, if you recall, on the previous slide, the requirement is that the application is not submitted using, quote, the form that FDA provides. It's pretty vague, right? So FDA has interpreted that requirement to mean not that you just need to use a form that FDA has issued, but it has to be the most recent and final version of that form. And FDA doesn't always tell you when they've updated their form, so you need to be vigilant about checking to make sure that you have the very latest version of the form. Because if you don't, they will refuse to accept your application. And my experience is appealing and arguing that that's not what the regulation says is not successful. So make sure you use the right form. Another basis that was pretty common over the last couple of years is that the PMTA doesn't include a signed statement by an authorized representative of the applicant certifying that an English language translation is complete and accurate. And sometimes that happened because of technical issues with the PDFs, and that the PDF thing is a whole nother can of worms. But make sure that if it's an ends product, you're gonna have probably documents in a foreign language. Make sure that you comply with all of those requirements. Another problem that has come up a lot is if you reference a master file, a tobacco product master file, a TPMF, but you didn't include an authorization to reference that TPMF, they've rejected the application, even when it's a TPMF filed by the applicant itself. Why would you need to have an authorization when it's your TPMF? FDA has said that you need that even if it's your own TPMF. Failure to identify an authorized representative or U.S. agent, and not signing the certification statement. These are all really, really ministerial problems that FDA has used to reject applications at the acceptance phase. And then, so let's say you get through the acceptance phase, right? You get to the filing phase. Now, filing review is a lot more in-depth. It's not just, do you have the right forms? Do you have the right signatures, certifications, and the like? So at this stage, FDA is really looking at, do you have all of the underlying information and data substantively that you need in the application? So this is a list of some of the things. There's some more. So your application has to include all of these elements, or FDA will refuse to file the application. So let's say you get past filing review, and FDA turns to scientific review, or so they say. And this was mentioned in the earlier presentations. If you're filing for a flavored product, FDA changed their policy after the submission, at least of the first bolus of applications for tobacco-derived products, to require that an application contains certain data to show that the flavored product, the non-tobacco, non-menthol flavored product, helps adults switch away from cigarettes more effectively than a tobacco-flavored product. And this has been referred to as a fatal flaw approach. It's been challenged in a number of the earlier referenced court decisions. So the way FDA has been implementing this relatively new approach is they just look at your PMTA and they say, does this include a randomized controlled trial or longitudinal cohort study that looks at this switching issue? If not, marketing denial order. They won't even look at any of the rest of the application. So that's been a real problem. So even if you get all the way to scientific review, you could easily be knocked out without really any scientific review, honestly. So we'll see how this plays out. It may, in fact, go to the Supreme. I mean, it's been there's been a filing for a cert at the Supreme Court, so it may well be looked at the Supreme Court. So we'll see how that plays out. So that's the PMTA front, and now substantial equivalence reports we haven't talked about too much today, and that's for products where you can reference a predicate, a product that was on the market on February 15th, 2007, and you compare your product to that product. And SE reports have been around for a lot longer than PMTAs. FDA has been processing SE reports since 2011. They have a little more experience with it. As referenced earlier, they've gotten through more SE reports than PMTAs. So, there are arguably fewer pitfalls here, which is kind of ironic because these are typically your combustible products, your products that are on the more harmful side of the risk continuum. So again, you start out with the acceptance phase, and this is from the rule that applies to substantial equivalence reports, what's required for acceptance. Similar requirements as the PMTA. But one of the things that's unique to the substantial equivalence report is that you have to compare your new tobacco product to a legally marketed predicate product. And you need to provide quite a bit of data about that predicate product to demonstrate to FDA that it's an eligible predicate product, meaning that it's grandfathered and it was not marketed exclusively in a test market as of February 15th, 2007. So it has to be considered a pre-existing product or a product that has been found to be substantially equivalent to a pre-existing product. And FDA is very, very, very picky about the documentation that you provide to show that the product was legally marketed as of February 15, 2007. And if you have any inconsistency with punctuation or capitalization between the documents from 2007 and the documents that you submit with your substantial equivalence report, FDA will raise issues. So if you had like a period in the name of the product in one document but not in the other, or if it's all caps in one document and not in the other, FDA will raise that issue. So you have to be very, very, very specific and detail-oriented here as well. So you have to have that linking information that shows that the product was on the US market not before February 15th, 2007, but on February 15th, 2007. That's a huge pet peeve of mine because the statute says as of February 15th, 2007, and FDA has interpreted that to mean on February 15th, 2007, which doesn't make sense to me, but anyway. So as I said, FDA, any perceived discrepancy, FDA will send you an email requesting additional information. They usually will only give you 3 to 5 days to respond, which is kind of insane. And then you need to submit your response to the Document Control Center or CTP portal. You can't email it back. I mean, you can email a courtesy copy, but that doesn't count as filing or responding. So if you do have to respond to these predicate eligibility requests, be very, very meticulous about your response. Reproduce each request, provide your response. Over-explain everything. They will not give you the benefit of the doubt in any way, shape, or form. It's nice to provide a table with the linking information, so it's very easy for FDA. You have to make it as easy as possible for FDA, really easy. And then if you know that they raised one issue with one predicate but not with another, if you know it could be an issue, just provide all the information right up front, even if they haven't asked for it yet. And then if you're citing a predicate that's not your product, it's somebody else's product, you need to explain the business relationship between those two entities. If you didn't manufacture the predicate, you need to provide an explanation of how you know that it wasn't exclusively marketed in a test market back in 2007. Okay, so that's the predicate eligibility review. Now, deficiency letters, and this applies to both PMTAs and SEs. Of late, FDA hasn't been issuing very many deficiency letters for PMTAs. They've been going directly to marketing denial orders in a lot of cases. So it's probably a good sign if you get a deficiency letter at this point, because that means that FDA is giving you a chance to rectify issues that it's raised. In the past, FDA has issued more than one deficiency letter if new things come up. Today, the FDA's policy appears to be that they will issue only one deficiency letter per application. So you need to fully respond to everything that's raised in that deficiency letter. Typically, your regulatory health project manager will contact you and offer you an email courtesy copy. You should definitely take them up on that offer because you want to see that deficiency letter as early as possible, because you typically only get 90 days to respond. And sometimes you need to generate data in that response. So you need to make sure that you use your time really effectively. They don't typically grant extensions, but sometimes you can get them to either officially or unofficially give you some extra time. So if there are like a couple of things that you won't be able to get to in the 90 days, submit your response within the 90 days and give them a timeline of when you're going to submit the later information and why you couldn't get to, like in detail with affidavits or whatever evidence you need, indicating why you couldn't meet that 90-day deadline for those particular categories. And a lot of the deficiency letters in the SE context, at least, ask for stability data. And our experience has been that 90 days of stability data can suffice for products without established shelf lives. Again, like the predicate eligibility review, reproduce in your response to the deficiency letter, reproduce each request, and then provide your response. Make sure, a lot of times they give background and then they give the deficiency. Make sure you're addressing specifically the deficiency letter that FDA cites. A lot of times FDA requests information about what they consider to be design features, but they may not be a design feature for your product. So provide that information, but make it clear that it's just a theoretical target or limit, and give the test data, but make it clear that it's not actually a design feature of your product. And then in responding, look back at the technical project lead summaries that FDA issues for its authorizations, for its SE orders, and cite to things that are applicable to your product, because FDA is not always consistent in its approach to substantial equivalence reports or PMTAs. And so if they've made a decision in the past that's inconsistent with the way they're approaching your SE report, you need to point that out and say, hey, you need to create a level playing field here. You allowed this data for this previous applicant to support their SE report, so you should allow it in this case as well. And this is just a couple of other points that we've noticed that typically if you're comparing a flavored new tobacco product to an unflavored predicate, FDA will just automatically reject that application in the SE context. But they have allowed changes in some flavors and characterizing flavors to go through. So, definitely don't submit an SE report comparing a flavored product to a tobacco flavored product, but you might be able to get away with some changes in characterizing flavor composition. And again, with stability data requests, FDA has now been taking a stepwise approach where the new tobacco product doesn't have increased water activity relative to the predicate product. They won't require any further testing data. So what if you get a denial or refuse to accept or refuse to file? What are your next steps? And so with a PMTA, marketing denial order, as you guys are probably aware, the statute provides that within 30 days of the date of the marketing denial order, you can go directly to the U.S. Court of Appeals, either for D.C. or for the circuit in which your applicant resides or has a principal place of business. You may have found that people are trying to bring their cases in the Fifth Circuit. If you have some connection there, that's probably a good strategy these days. Seems like the Fifth Circuit is most empathetic in this context. So you can do that. You can go directly to the Court of Appeals. You can also seek supervisory review at FDA of a marketing denial order under the regulation that allows for that. My experience is it's kind of a wasted effort because when the agency issues a marketing denial order, it's already gone up to those levels of review, so they're on board. So if you do an internal FDA supervisory review request, it's typically not successful. If it's not successful at the supervisory review phase, you can also appeal to the commissioner's office after that. But again, all of these decisions typically have gone up that high already, so it's my experience is sort of a wasted effort. And to appeal a PMTA refuse to accept or refuse to file or a not substantially equivalent order, you cannot go directly to the Court of Appeals in those contexts. You do have to engage in the supervisory review process, or you can go to district court and challenge it on the grounds that it's either arbitrary and capricious or FDA didn't comply with their statutory mandates. I think that's it. So thank you very much and look forward to questions during the panel later.